My name is Melissa Harrison, and I'm an associate professor of law here at the University of Montana School of Law. I teach the courses here in criminal law and criminal procedure. It is my privilege to welcome you to this session of the Montana Supreme Court. I extend a special welcome to those of you who will be witnessing a Supreme Court argument for the very first time. For a number of years, the Montana Supreme Court has made it a practice to hold some sessions of the court outside of Helena. The court makes this special effort in order to assist the citizens of Montana in better understanding our judicial system and the role of judges and lawyers in that system. When you leave here today, you will be part of a distinct and honored minority of citizens of the United States who have had an opportunity to see their highest court in action. Most individuals simply never get the opportunity to see the workings of their highest court. Our Montana Supreme Court is to be commended for affording the citizens of Montana such an opportunity. The Montana Supreme Court is this state's highest court and this state's only appellate level court. 7 justices make up the Supreme Court, including Chief Justice Gene Turnage and Associate Justices William E. Hunt, Terry N. Trewiler, Carla Gray, James Nelson, William Leaphart, and James Regnier. After my introduction, the justices will enter the courtroom. We will stand. Then, the Chief Justice will announce when the court is ready to proceed. The lawyer for the state of Montana, represented by the Attorney General's office, will argue first. They are the appellants in this case. Then, the lawyers representing the plaintiffs will argue. They are the respondents. After the argument, the court will take the case under advisement and issue an opinion in the case. This may take anywhere from a few weeks to a few months, depending upon the caseload of the court, which, by the way, is extraordinarily high, one of the highest caseloads in the entire country. Our Supreme Court deals with almost 800 cases a year. That compares with the United States Supreme Court, which hears about 75 cases a year. On December 6th, 1993, the plaintiffs in this case, 6 Montana residents who are homosexuals, filed a declaratory judgment action, which means that they sought a declaration by the court that a Montana criminal statute, which is Statute 45-5505, consensual sex between adults of the same sex, court in Helena. Section 45-5505 imposes prison terms of up to 10 years and fines of up to $50,000 for knowingly engaging in deviant sexual relations or causing another to engage in deviant sexual relations. Deviant sexual relations include sexual contact or sexual intercourse between 2 persons of the same sex or any form of sexual intercourse with an animal. Plaintiffs challenge that portion of the statute which criminalizes consensual sexual contact or sexual intercourse between adults of the same sex. The district court below, Judge Jeffrey Sherlock of Helena, found that that portion of the statute violates Montana's constitutionally guaranteed right to privacy, set forth in Article 2, Section 10 of Montana's Constitution. Therefore, the lower court granted summary judgment in favor of the plaintiffs. That means that the plaintiffs won below and the state lost. That is why the state is the appellant here and the plaintiffs are the respondents. The state of Montana is appealing to the Montana Supreme Court the decision of the court below that the statute is unconstitutional as applied to sexual activity between consenting adults of the same sex. Remember that I said that this is a challenge under the Montana Constitution. This is a very important fact. The constitutionality of statutes can be challenged under either the U.S. Constitution or the Montana Constitution, or both. This is not a challenge under the U.S. Constitution. The United States Supreme Court, in a case called Bowers versus Hardwick, declared that there is no fundamental right to engage in homosexual conduct under the Due Process Clause of the United States Constitution. However, this case challenges the statute under the Right to Privacy Clause of the Montana Constitution. Unlike the federal Constitution, which does not contain a textually explicit right to privacy, the Montana Constitution does. Article 2, Section 10 of the Montana Constitution states that the right of privacy is essential to the well-being of a free society and shall not be infringed without the showing of a compelling state interest. The respondents also challenged the statute under the human dignity provision of the Montana Constitution. Article 2, Section 4 of Montana's Constitution provides that the dignity of the human being is inviolable. Lastly, the respondents are also challenging the statute based on the Equal Protection Clause of the Montana Constitution found in Article 2, Section 4. The fact that the statute is being challenged under the Montana Constitution means that the decision of the Montana Supreme Court is the final decision on this issue. If the case were based on the United States Constitution, then it could be appealed to the United States Supreme Court, but not if the decision is based on the Montana Constitution. I will now briefly, I promise, describe what the issues are in this case and the arguments you might be expected to hear today. Each side has filed briefs in this case, which lay out their arguments for the court. The court has read the briefs, and they will today ask the lawyers questions about the case. You may hear some reference to things that are called amicus curiae briefs, and that word literally means friends of the court. There have been such briefs filed in this case by several groups, and it means that groups with an interest in the case can file a brief stating what their interest is. In case they're referred to, I would like to tell you about the amicus briefs that were filed in this case. Supporting the position of the state of Montana, a brief was filed for the Montana Citizens for Decency Through Law. For the respondents, a brief was filed by the following groups: the Lambda Legal Defense and Education Fund, the American Civil Liberties Union, the Montana Human Rights Network, Pride, Women's Law Section of the State Bar of Montana, Montana Women's Lobby, and Parents and Friends of Lesbians and Gays. Also for the respondents, a brief was filed by the Women's Law Caucus, a section of the Student Bar Association of the University of Montana School of Law, and also by individual professors from the University of Montana School of Law. The first issue in this case is whether the respondents have standing to challenge the statute. In order to challenge the constitutionality of a statute, the persons wishing to challenge the statute must show that they are harmed or face a threat of harm because of the statute. The respondents allege that they easily satisfy the standing requirements because they have indicated that they are actually damaged by the statute, because they have suffered emotional damage because of the existence of this statute. Since they fear prosecution, they fear that their potential status as felons under the statute endangers their careers and endangers their parent-child relationships. In addition, the plaintiffs presented testimony that the existence of statutes such as the one here in question is detrimental to the self-esteem and self-image of lesbians and gay men. For example, from the record, as one of the respondents testified, and I quote, "The fact that I always try very hard to live responsibly and morally, and being compared to people who molest animals is tremendously offensive to me. It's just very hard to be categorized because of something so central to myself. I am being categorized as less than human. Just being set aside as a felon for something so important to me is very demeaning." The state argues that respondents lack standing to mount a challenge to the statute because it has never been applied or threatened to be applied to them. The state argues that because there have been no reported decisions in Montana applying the statute to sexual conduct between consenting adults, that plaintiffs have suffered no injury because of the statute. According to the state, standing requires an allegation of a present or immediate injury in fact. The state argues that the plaintiffs face no present or immediate injury in fact because they have not been arrested under the statute and there is no immediate threat of being prosecuted under the statute. The district court below found that the plaintiffs were directly affected by the operation of the statute they attack. The court found that their right to engage in private, adult, consensual homosexual relations was adversely limited by the enforcement or threatened enforcement and very existence of the statute. Further, the court found that although no one has been prosecuted for private, consensual adult activities under the statute, the legislature has resisted its appeal in the legislative sessions of 1991, 1993, and 1995, and thus the court found that there can be no guarantee that the statute is moribund or that the legislature does not intend that it be enforced. The next issue is whether the statute violates the right to privacy under the Montana Constitution. The state will argue that the right to privacy under Article 2, Section 10 does not immunize same-sex sexual activity from state regulation. First, they argue that the fact that the delegates to the 1972 Montana Constitutional Convention rejected an explicit proposal to declare that private sexual acts between consenting adults are not a crime. According to the state, the issue then becomes whether the convention intended to do indirectly in Article 2, Section 10, that which it had been asked but refused to do directly. The state argues that nothing in the debate surrounding the privacy provision's adoption suggests so. The respondents argue more broadly that Montana's Constitution makes a strong commitment to individual privacy. They point to several cases by the Montana Supreme Court where the court has declared that privacy rights of individuals in Montana are more substantial than the rights guaranteed in the United States Constitution. The respondents argue that the debate of the Constitutional Convention makes it clear that the right was intended to protect citizens from governmental practices that interfered with their autonomy to make decisions in matters that are generally considered private. As one delegate explained, and I quote from the brief, "As a participating member of society, we all recognize that the state must come into our private lives at some point. But what the Privacy Clause says is don't come into our private lives unless you have a good reason for being there. The respondents argue that the test for privacy is whether there is a reasonable expectation of privacy in the activity. They argue that consenting adults reasonably expect their sexual expression to be private. The state argues that the more appropriate test for determining whether a fundamental right exists to engage in same-sex sexual activity is the standard used in Palco versus Connecticut, a United States Supreme Court case, and also in later substantive due process decisions which define the scope of substantive due process rights in a personal autonomy context. The district court below decided that respondents had a subjective expectation of privacy with respect to private consensual sexual conduct because a person's decision as to sexual matters is probably one of the most private areas of a person's life. The court below next held that society is in fact willing to recognize as reasonable the expectation of privacy in adult, private, consensual, same-sex relations because the statute has never been enforced against such activity. It stated, and I quote, "Montanans generally mind their own business and do not wish to restrict other people in their freedoms unless the exercise of those freedoms interferes with other members of society." The district court below invalidated the statute on the basis of Montana's right to privacy clause, but the respondents rely on two other constitutional provisions to invalidate the law. Section 4 of Article 2 of Montana's Constitution provides the dignity of the human being is inviolable. The plaintiffs argue that criminalizing adult sexual conduct violates the guarantee of human dignity. They argue that the plain meaning of the word dignity demonstrates that the clause is violated by labeling as deviant people who engage in consensual same-sex practices. They argue that dignity demands that each individual be permitted to participate equally in the honors and opportunities available in this society. The state argues that the dignity provision of Article 2, Section 4 is not a separate provision from the Equal Protection Clause. They also argue that it is difficult to determine what dignity means. They state that dignity referred to in the clause should not be isolated from the remainder of Article 2, Section 4, and instead should be construed to mean the quality of being worthy or honorable resulting from equal protection of the laws and freedom from the forms of discrimination prescribed in that provision. Any other construction, according to the state, creates a class of fundamental right that by virtue of its indefinite quality will be bound only by the imagination of complainants and courts sympathetic to their cause. Finally, the respondents argue that the statute violates the equal protection guarantees of the Montana Constitution. They argue that the Equal Protection Clause affords protection from arbitrary legislative acts. All legislation which draws distinctions between persons must draw those distinctions based on what we call a rational basis. The respondents first argue that homosexuals should be classified as a suspect class because of the discrimination that this group has suffered, and that as a suspect class, the law should be considered by the court under what is called strict scrutiny, a higher form of scrutiny, if you will. But the respondents also argue that even under the more lenient rational basis test, that there is no rational basis for the distinctions which are made in this statute. First of all, the respondent argues that the statute does not specify certain acts which are forbidden. It only makes a distinction based on who is committing the acts. And the respondents argue that this is discriminatory and that dislike of a particular group cannot form the basis for such a classification. The state argues that societal notions of appropriate sexual conduct provide rational grounds for the classification in the statute. The state also makes an argument that public health concerns provide a rational basis for the statute. The plaintiffs argue that the public health argument must fail, given that the statute was passed before the AIDS virus was diagnosed. It criminalizes sexual activities between women, which has the lowest risk of the spread of AIDS. And the respondents also point out that most public health groups are opposed to the statute. In summary, the respondents are mounting a challenge to the constitutionality of this statute based on 3 provisions of the Montana Constitution. The state is defending the constitutionality of the statute based on those same 3 provisions. I think it will be a very interesting argument. I thank you all for being here. I hope this introduction has been useful. Thank you very much, and enjoy the argument.
That's not fair.
Corky, come on.
But you're double teaming.
All right, give your attention. The Honorable Justices of the Montana Supreme Court.
The court would first thank the School of Law at the University of Montana for making these premises available for this oral argument. And also we want to thank all of the audience that's in attendance, and we hope that in witnessing the Supreme Court of Montana in live action, it will be somewhat beneficial to you and to the public in general. I would take a moment now to introduce the Supreme Court, and also I would want to first introduce David McAlpin, who is our Marshal and Deputy Clerk of the Montana Supreme Court. And starting over on David's end of the bench, Justice Terry Treeweiler, and sitting next to Justice Treeweiler is Justice Carla Gray. Next to Justice Gray is Justice James Nelson, and my name is Gene Turnage, and proceeding on to my right is Justice James Regnier, and next to Justice Regnier is Justice William Leaphart, and next to Justice Leaphart is Justice William E. Hunt. And with that introduction, we're now ready to call the case 96202, Gryzcan against the state of Montana. Gryzcan is the plaintiff and respondent, and the state of Montana is the defendant and appellant in what started out as a declaratory judgment action below and is now here on appeal. Is the appellant ready?
The state is ready, Your Honor.
Very well. And the respondent? Very well. You may proceed.
Mr. Chief Justice, and may it please the Court, although the enforceability of Montana's deviant sexual conduct statute with respect to same-sex sexual activity is at issue in this appeal, this case is more about the appropriate role of courts in our Republican form of government than it is about the appropriateness of certain forms of sexual behavior. It is, in short, about whether this court is willing to involve itself in an essentially political dispute of great sensitivity and to determine judicially that which we respectfully suggest should be decided legislatively. Broadly speaking, there are two issues before the court today. The first is whether a justiciable controversy exists under Article 7, Section 4.1 of the Montana Constitution. And second, if there is such a controversy, whether the right to engage in consensual same-sex sexual activity between consenting adults is a fundamental right under our state constitution. The facts material to this case are undisputed. The plaintiffs are 6 gay and lesbian Montana residents.
Counsel, just so I understand the analytical process you're asking us to undertake, I thought the issue was whether the right to privacy was a fundamental right under our Constitution and whether the activity of consensual sex was protected by the right to privacy.
Your Honor, that's one of the issues. But as I will discuss, the issue of whether there is a right of privacy with respect to the kinds of conduct in question in this case turns, in essence, on whether that form of conduct is the kind that we believe would be deemed a fundamental right using analysis that has been adopted under the United States Constitution.
Well, there's no question but that the right of privacy is a fundamental right under our state constitution, is there?
No, Your Honor, of course not. That's provided specifically in Article 1, Section 10. But the issue, of course, is whether or not the form of conduct in question in this case is encompassed within the right of privacy. That's one issue. There are several other, obviously enough.
And so that I'm still tracking you, in the past we've applied the two-part test from Katz to determine whether an activity in Montana is protected by the constitutional right to privacy. Isn't that correct?
You have, Your Honor, with respect to what I will call informational privacy cases. The court, to my knowledge, has determined only, or decided since 1972, only one, what I will call autonomy privacy related case.
Which case was that?
And that's town of Ennis versus Stewart.
And in Ennis we applied the two-part Katz test, didn't we?
Your Honor, actually, for relevant purposes, you provided, the court applied in one portion of the opinion the two-part Katz test, and in the latter part of the opinion, what I will call the Palco test.
Okay, thank you.
Certainly. Again, the facts in this case that are relevant, I think, to the court's determination are undisputed. The plaintiffs have pled, and there's no question that they have engaged in, are engaging in, and intend in the future to engage in same-sex sexual activity. There is no question that they have not been prosecuted or threatened with prosecution under Section 45.5.505, our deviant sexual conduct statute. Indeed, the record shows no instance of any prosecution under that statute, which was adopted in 1973.
Well, if there's admitted homosexual activity, aren't the county attorneys under a legal obligation to prosecute?
No, Your Honor. As with any form of alleged conduct that is criminal in nature, county attorneys have discretion to determine whether prosecution is appropriate.
Well, if they have information before them that the law has been violated, don't they have a legal obligation to enforce the law?
Again, Your Honor, the decision to prosecute is one committed to the discretion of the county attorney. There are also, obviously enough, instances. This is a form of conduct which, as we suggest in our brief, is exceedingly difficult to prove because of corroboration aspects.
Well, if the activity is admitted, wouldn't that be sufficient proof?
It depends, Your Honor. Under Section 4615.215, a mere admission or confession is insufficient in and of itself. If it is extrajudicial, the issue, for example, in this case, would be whether any statements or admissions and pleadings would be deemed judicial for purposes of that statute. That is an issue that we have not explored in this case to date.
Counsel, if the state has no plans to prosecute anyone under this statute, why is its validity significant enough to appeal to the Supreme Court?
Your Honor, the issue is whether the state has any plans to prosecute the plaintiffs in question, and the answer is, as far as I can determine, no. The issue is important because the district court declared unconstitutional a state statute. And when a district court does that, and the Attorney General believes there are reasonable grounds upon which to sustain the constitutionality of that statute, then we feel obligated to appeal.
Well, why is the statute important if there's never been a prosecution under it? In all likelihood, there never will be a prosecution because it's so hard to gather evidence to bring a prosecution to court. Why is the statute important?
Your Honor, all statutes are important. This one included.
What is its importance?
Its importance is that it has been adopted by the legislative branch of our government. Now, whether or not it can be enforced as a practical matter is really a subsidiary, and I would suggest for purposes of this case, not a terribly important issue, except as it may relate to issues of justiciability.
Well, except that under your justiciability argument, you contend that there's no threat of it being enforced. But then in response to the equal protection argument, you say that the rational basis for the test is that it deters same-sex activity and thereby eliminates the frequency of communicable disease. How can you reconcile those two positions?
Your Honor, the question of justiciability obviously differs in its analytical significance to the question of whether there is a rational basis for the statute. With respect to the standing issue, the justiciability issue, the question, of course, is whether the plaintiffs have established what federal courts have called a credible threat of prosecution. Now, if they have not, and we suggest, of course, they have not, this case ends. Now, to the extent the court concludes that there is a credible threat of prosecution or otherwise determines that we have a justiciable controversy before us, then, depending on the standard of review adopted, we can get to the question of rationality. As I suggested, the mere fact that the statute is difficult to enforce does not mean that the legislature has no plausible basis upon which to enact, or for that matter, to maintain the statute in existence. That plausible basis, as we suggest in our brief, is the legislative determination or possible legislative determination that the statute's mere existence may retard the conduct which the legislature believes is inappropriate.
Well, see, that's what I can't understand. If there's no credible threat of prosecution, then who's to be deterred from engaging in same-sex activity by this statute?
Your Honor, there are many people we would suggest that the legislature could plausibly believe will obey a statute, a law, merely because it is a law. There are any number of statutes in this state that people comply with, even though if they had their preference, they would not. And even though they recognize that the likelihood of being prosecuted for violation is minimal to nil.
Where are all these purposes found that the legislature has deemed appropriate to enact and maintain this law in existence? Are they in the legislative history? They're certainly not in the text of the bill itself or the law itself.
Your Honor, as this court has held in a number of cases, there is no requirement that there be legislative history articulating grounds that satisfy the rational basis test. The issue is whether or not this court can conceive of any such grounds.
That's what this court said in Stratemeyer. How can you reconcile that with its subsequent decision in Arneson?
Your Honor, we of course discussed that issue in our reply brief. Arneson did not, we believe, substitute what has been a longstanding rationality analysis of this court with some form of heightened rational basis scrutiny. In Arneson, the court merely concluded that the statute there, which distinguished between the descendants, or I should say the heirs, of retirees who had died on the basis of age or disability, was irrational because it did not further or relate to any legitimate state goal.
Well, applying the anything goes test from Stratemeyer, we certainly could have concluded that that distinction saved money for the retirement fund, couldn't we?
Yes, you could have concluded that.
But we didn't.
But the issue, of course, is whether the method used to save money, in this case, distinguishing between descendants or survivors of individuals, retirees who had died, who were under 55 as opposed to those who were 55 or older, was a rational base or legitimate or rational way to achieve the objective of saving money, which everyone would admit is a valid one. And I think explicit in the decision, is that that was not a rational way of achieving that goal. In this case, there can be no question that if the legislative goal is to retard a form of conduct which the legislature believes is inappropriate, that the means selected, i.e. prohibition, is a perfectly rational way of achieving that goal. So in this case, the real question is the legitimacy of the goal itself, that is to say, eliminating or retarding same-sex sexual activity.
And that's because of health reasons? Is that the idea?
Your Honor, we relied principally on notions of the legislature's ability to determine what constitutes appropriate sexual mores.
Well, can people be denied the equal protection of the laws because one portion of society has the perception that conduct is immoral that another portion of society is committing?
Your Honor, we would argue that the plaintiffs or the respondents in this case are not denied equal protection of law. But if the court's question is whether society's views of morality may constitute an appropriate basis for legislation, I think the answer is clearly yes.
Well, if the legislature's notion of morality was the test for a rational basis, then no statute would ever violate the Equal Protection Clause, would it?
Your Honor, I think the answer is no. I think, or put it this way. No, I do not believe that using that test means that every statute that the legislature adopts would satisfy the equal protection provision.
Isn't every statute, every criminal statute enacted by the legislature a reflection of the legislature's notion of morality?
I think that's precisely our point, Your Honor, and the answer to that question is yes.
Well, what's the limits? What test do you employ when you start enacting legislation on the basis of somebody's perception of morality?
Your Honor, I think the limits are those imposed by tradition in history and any other grounds that may justify the legislation in question. In this case, for example, the legislature obviously was not writing in 1973 upon a clean slate. The state of Montana, and before the state of Montana existed, the Montana Territory had a statute in place which prohibited this form of conduct.
By everybody, men and women.
That's correct. It was a crimes against nature case which did not distinguish between heterosexual and homosexual conduct. But the absence of that distinction didn't make the conduct in question here any more lawful. And that's my point. The legislation we have before us, whether or not it accords with some more contemporary notions of what constitutes appropriate social legislation, nonetheless has ancient roots, both in this state and other states throughout this country.
Well, if sodomy is immoral, and I guess that's what the legislature is saying, if that's immoral, why is it not immoral between a man and a woman? Because it's not criminalized in Montana, but it is immoral between two consenting adults of the same sex.
Well, I think the court is asking, obviously, the equal protection issue in this, the question going to the basis for distinguishing between heterosexual and homosexual conduct. And I think that arguably the legislature could have prohibited both forms of conduct outside certain contexts. And I think the notion of outside certain contexts points up the problem with prohibiting heterosexual conduct. It's the state's position that sexual conduct, qua sexual conduct, divorced of any other considerations, is not a fundamental right, regardless of whether it is engaged in by same-sex or opposite-sex couples. Now,
people don't have a fundamental right to have sex?
Well, that's correct, Your Honor.
Is it a right of any kind, counsel?
Let me, if I can finish my thought, I think I can answer your question, Justice Gray. With heterosexual conduct, we have other considerations which oftentimes protected within very, very well-established notions of privacy, or at least fundamental right status. The most obvious example, I suppose, is the Supreme Court's decision in 1978 in Eisenstadt versus Baird, which in essence stated that the state of Massachusetts could not prohibit the sale of contraceptives to a woman, an unmarried woman, because it affected her reproductive rights, extending, of course, the court's earlier decision in Griswold versus Connecticut, which involved a married couple. My point there is that the fundamental right at issue in Griswold and later in Eisenstadt was the right of reproduction. Now, no one disputes the biological fact that sexual conduct between heterosexuals can implicate the reproductive considerations. And that is why when a legislature attempts to regulate heterosexual conduct, it runs into a different type of difficulty that it does not run into when it attempts to regulate same-sex sexual conduct.
But, counsel, the distinctions you're talking about have all been made under interpretations of the substantive due process portion of the 14th Amendment to the United States Constitution. They've not been made under the privacy provision in Article 2, Section 10 of Montana's Constitution, have they?
No, Your Honor. I mean...
What we're talking about here is, first of all, whether privacy is a fundamental right in Montana, and secondly, whether the right to engage in sexual relationships between two consenting adults is included in that right to privacy, aren't we?
That's correct.
And if we apply the two-part Katz test, we first have to decide whether the petitioners in this case had a subjective expectation of privacy, and second, whether it's one that society is willing to recognize as reasonable, don't we?
If you apply the Katz test, that's correct.
And if it's protected by the right to privacy, then the state has to establish a compelling state interest for precluding this activity, doesn't it?
Correct.
And what would be the compelling state interest in this case?
Your Honor, we've never contended there is a compelling state interest that justifies the statute.
So if we conclude this activity is protected, then that's the end of our inquiry?
If you conclude that this conduct falls within the scope of the privacy provision, that's correct. And if, of course, the court concludes there is a justiciable controversy in the first instance. Let us turn for the moment to the Katz test and why, in the state's view, it simply does not apply in this case. Because if it does apply in this case, then this is a very easy case for the court. First of all, under the...
Easy to affirm or easy to reverse?
Easy to reverse. Assuming, of course, again, the court finds justiciable controversy.
I assumed that would be your answer.
And I think my analysis will show, as we did in our brief, how inapposite the informational privacy standards in Katz are to this case, because I think it makes it a much easier case than perhaps it actually is. If we apply the first prong of Katz, namely whether the plaintiffs in this case have a subjective expectation of privacy, then the answer to that question clearly is no. They have come forward and disclosed to the public their sexual conduct. It is not the state which is intruded in a kind of informational sense into the privacy of their respective bedrooms. So, for example, under a typical Katz analysis...
Do you mean that if two heterosexuals disclosed that they had had prior sexual relations, that they would then forever waive their right to privacy while conducting those relationships?
Your Honor, if this court is going to apply the Katz standard, the answer would be yes. Because how can there be a subjective expectation of privacy with respect to conduct that the actors, or at least one of the actors, voluntarily discloses?
So under the Katz test, heterosexuals in Montana would have no right to privacy for their sexual activity.
Your Honor, I think that to the extent we are talking about governmental intrusions and for purposes of determining whether they're having that kind of sexual activity, yes.
It seems to me that you're suggesting that by filing suit to vindicate the right, you lose the right.
Well, I think that's true if the court applies the Katz standards. And that's one of the reasons why we suggest it doesn't make any sense. Because if you conclude that the plaintiffs have satisfied that the Katz standard does apply and that the plaintiffs indeed have satisfied it, then what the court is saying is that merely by claiming a right, you satisfy the subjective standard test. Well, that essentially means that there is no first element of the Katz test.
Isn't that the nature of any subjective test?
No, it isn't, Your Honor, I would suggest.
Well, how would you establish a subjective expectation without claiming it?
Well, in a traditional search and seizure case, it's usually fairly clear. The defendant obviously has engaged in clandestine activities designed to preclude the state from discovering certain kinds of information. But, for example, in a search and seizure case, if a defendant discloses certain information to a third party or to a second party, it may well be, a court may well and likely will conclude that that person the defendant had no subjective expectation in the privacy of that information or in the confidentiality of that information.
Isn't there a real basic difference between privacy under Article 2, Section 10 and privacy in connection with search and seizures? It seems to me that the essence of what the framers of our Constitution were talking about in Article 2, Section 10 was the right to be let alone. Isn't that the essence of what privacy is all about? The right to not have the government in your bedroom and in your face constantly.
Oh, Your Honor, I agree that Article 2, Section 10 and Article 2, Section 11 have really quite distinct purposes.
Then why is Article 2, Section 10 not implicated in this case, absent of trying to apply the Katz test?
Well, Your Honor, I would argue that indeed Article 2, Section 10 is implicated, and that the question of whether it has been violated is determined by a different set of standards other than Katz, namely PALCO standards, because, in large measure, the very purpose of Katz was to give flesh and bones to the Fourth Amendment, i.e. the counterpart to Article 2, Section 11, not to give flesh and bones to the Due Process Clause, either of the Fifth Amendment or the 14th Amendment. The latter issue, the latter concern, is really that of PALCO in later cases. And that is, of course, a principal point in our brief. But going back to Justice Trueweiler's question, again, I think this case is very easy from the state's perspective to resolve if you apply Katz, because by its very nature, the plaintiffs have not satisfied the first element, and by the very nature of the second element, which is an objective element based on what whether society would conclude that the privacy interest at stake was indeed protected. The objective prong is clearly answered by, one, the existence of the statute itself, passed by our legislature, which under our Republican form of government, again, is really the reflection of society rather than this court.
Is that really all that clear, though, in light of the fact that our elected prosecutors are choosing not to enforce it?
Your Honor, what...
Doesn't that reflect some of the perceptions of society?
It may, Your Honor, but the more, I think, critical determination is not whether county attorneys exercise prosecutorial discretion in one way or another, but whether, in fact, the legislature has opted to enact and maintain in place a particular statute. Now, of course, if I might just finish the thought about the objective prong of Katz, Montana does not stand alone in prohibiting same-sex sexual activity. 40% of the other states in this country do the same thing, 22 excluding Montana. So I think from a purely Katz perspective, the plaintiffs have a substantial uphill battle. And it's one that, for some reason, they've elected to undertake, but I think to the disadvantage of their own case. The state is concerned about developing coherent principles in this area of law, which is why we have suggested to the court that Katz doesn't apply and that PALCO does. Now, I think the applicability of PALCO is clear, at least in terms of it being the proper analytical approach to resolving what I think is a difficult question. It is, of course, the basic approach used by the Supreme Court in Bowers versus Hardwick. It is indeed, I'm sorry.
Isn't PALCO a more substantial standard primarily because there is no express right to privacy in the United States Constitution, and because one has to be inferred from all of the other rights provided expressly in the United States Constitution?
Your Honor, I think that's a subtle question, and I'm...
No, I didn't mean it to be.
Well, no. I mean, I think it's a subtle question because I think there's some dispute now exactly whether there is a right to privacy as such under the Constitution. Obviously, if one reads Griswold, the answer is yes, although you have to pick and choose from various provisions of the federal Constitution, but you get one. And the right of privacy, of course, underlay the 1973 decision in Roe v. Wade. Subsequently, the court has focused more, at least in the abortion context, on notions of liberty. But I think in the final analysis, we're talking labels, and I don't mean that in a derogatory sense. I mean, we call what we may call substantive due process in the federal context. I think we can equally call privacy for purposes of Article 2, Section 10, because at their core, both inquiries are intended to ferret out the what oftentimes I think is a difficult answer. That is to say, in this context, notwithstanding the general right to privacy, does a particular form of conduct fall within the scope of the privacy provision? And to make that determination, of course, the court has to apply some form of standard. And the question is, what is that standard? Now, this court can, of course, formulate its own standard.
Well, setting aside for a second Katz and Pelko and standards and criteria, can you tell me of anything that the average person in society doesn't consider more private than his or her sexual relationships?
Your Honor, I think the answer to that question is very few things. But I don't think that answers that resolves the question in this case.
Well, then if an express right to privacy doesn't protect something that most of us assume is as private as sexual relations, then what would it protect?
Your Honor, I think that the right to privacy protects many things, but ultimately, when we're talking about a form of conduct, a form of sexual conduct, this court has to look beyond notions of what it would like to be disclosed or not be disclosed in its own individual context.
Well, we're not talking about the form of conduct, we're talking about the people who commit the conduct, because the same sexual acts that the legislature have prohibited between consenting adults of the same sex are not prohibited between people of opposite sexes. So we're really not talking about conduct, are we? We're talking about the people who commit the conduct.
Your Honor, I think the fair answer to that question is we're talking about both. We're talking about conduct, which in this instance includes the actors, the sexes of the actors. So I'm not sure that there's a neat distinction between the two.
Well, on the one hand, certain types of sexual relations between men and women are not prohibited. Those are considered private, I would take it, protected by the Privacy Clause of the Constitution. Yet, as I understand your argument, those same exact acts on the part of consenting adults who are of the same sex are not protected by the right of privacy.
Well, Your Honor, as I attempted to explain before, the sexual activity, qua sexual activity, stripped of any other considerations, is not, in our view, protected by Article 2, Section 10. There are other considerations, however, that may well make it constitutionally protected. For example, my Eisenstadt reference and notions of reproductive rights. Also, the Supreme Court has recognized in a number of cases that there is a strong privacy interest with respect to marital relationships, because the family has been deemed to be central to our society. So, again, I don't believe that the mere fact that sexual activity involves only heterosexuals makes it constitutionally protected. Well, what the legislature has determined to do is in essence, to allow that form of activity to be decriminalized to the extent that it had that authority.
Well, as I understand your position then, if the legislature had a mind to do so, it could criminalize non-procreative sex, it could criminalize fornication, it could criminalize adultery, it could criminalize practically anything
It could.
in terms of sex. Is
That's
that your
right.
position?
I believe within, these statutes have to be drawn fairly carefully, but yes, there are any number of kinds of sexual activity that are not criminal now, but that arguably could be criminalized. This state, for example, for a long period of time criminalized adultery. Half the states in our country criminalize adultery.
And all of the potential criminal offenses to which you just referred, counsel, would, in your view, withstand a constitutional challenge under the right to privacy?
They could. It really, again, depends on the particular facts. In this kind of case, unlike the case we have before us, but when we're dealing with issues of sexual conduct and whether or not the conduct in question is constitutionally protected, I think close attention has to be paid to the facts. There are, in fact, no facts in this case, other than essentially the allegations, not the allegations, but the admissions that the plaintiffs engage in same-sex sexual activity.
Counsel, in simple terms, why isn't the conduct that we're talking about here protected by Article 2, Section 10? What is your simple response to that?
The simple response is that same-sex sexual activity has never, at least in the tradition of this country, in this state, been viewed as what we would call a fundamental right. It has been regulated like many other forms of sexual conduct and prohibited. Under the Palco analysis, there is not the kind of tradition that is associated with fundamental rights.
And that's the tradition recognized by the legislature?
It's a tradition recognized by the legislature and then of course, by our legislature, and also over the course of time by most other legislatures in other states.
Counsel, if we get to the equal protection issue, under your rational basis argument, is it still the state's contention that one of the two rational bases for this statute is the prevention of the spread of disease?
Your Honor, the answer is yes, but frankly, that aspect of our analysis doesn't get us to where we want to go. That is to say, at best it works with respect to same-sex sexual activity between males. We're concerned with saving the statute as a whole.
So the only rational basis then the state would have left is the moral standards of society as established by the legislature.
Are we speaking now with reference to the equal protection issue?
Yes.
The other grounds for it would be that, as I've explained, the legislature could rationally determine that decriminalizing prohibition of non-marital heterosexual conduct, or essentially decriminalizing heterosexual sexual conduct generally, was appropriate because of the additional constitutional considerations that may come into play with that form of conduct. Again, going back to my Eisenstadt reference. There can be marital or non-marital considerations that relate to notions of reproductive freedom. There can be other more generalized family-related considerations which have been recognized by the court. By the court, I mean the Supreme Court, as well as this court for that matter. Your Honor, I'd like to, for a few moments, just go back, if I could, to the justiciability issue in this case. Because although we've been discussing the merits, I think the issue of standing is really is a principal concern in this case, because as I've said, the dispute here is one of great sensitivity. and it is one that implicates the authority of this court as opposed to the authority of the legislature. We have here a situation where there is no credible threat of any of the plaintiffs being prosecuted. The cases they have relied upon really do not get them where they want to go with respect to the existence of a dispute that requires this court to act. So, for example, in Lee versus State, the principal Montana Supreme Court decision they rely upon, we had a statute that had been enforced between 1974 with the Attorney General's proclamation and when that suit was initiated and it was decided by this court in 1981. There was no question that if Mr. Lee drove and it was observed driving in excess of 55 miles per hour, he was likely to be prosecuted. That, of course, is not true here.
Where is the record that there's no likelihood of prosecution here?
Your Honor, the record, insofar as it exists, is contained in the depositions, all of which indicate, of the plaintiffs, all of which indicate the lack of any threat of prosecution, or for that matter, any loss of employment or licensure as a result of the statute.
Well, the record also indicates that the very existence of this law is of great psychological pain to them. They're essentially doing an act that the Montana State Legislature has criminalized, and that's troubling. It's bothering.
Your Honor, but that may be true, and we've never disputed that. But that doesn't establish standing, does not establish injury in fact for purposes of standing. The mere existence of a statute has never been held sufficient in and of itself to constitute injury in fact. It is only the enforcement or threatened enforcement of a statute that gives rise to that kind of injury.
In the last session of the legislature, a member of the Attorney General's staff, one of the leading prosecutor, testified at the legislature that county attorneys were unlikely to enforce this statute. And there was a bill before the legislature to repeal it. And in spite of that testimony, the legislature declined to repeal the statute. Doesn't that give some indication that at least the legislature intends that it be enforced? I mean, it bears a 10-year, $50,000 fine penalty.
Well, it may well be that the legislature intends that it be enforced, but that intention is not material to whether the individual plaintiffs, this is not a class action, whether the individual plaintiffs have been threatened with enforcement.
Isn't your argument basically that the judicial branch of government should not ignore the will of the legislature because the executive branch is already doing that?
Your Honor, again, I go back to the question, or to the fact that the plaintiffs have the burden of showing a likelihood of prosecution. And regardless of whether county attorneys should or should not be enforcing the statute more aggressively, the fact is they've not established that predicate.
So your answer is yes?
No, Your Honor. My answer is that the court must simply determine whether these individual plaintiffs are likely have adduced evidence to indicate a likelihood of prosecution. And the answer to that question, based on the district court record, is no. Your Honor, I'd like to reserve...
I'm going to do this. I think the time ran over, but we'll give you 5 minutes for rebuttal. Is that all right?
That's fine. Thank you very much.
And we'll give you an extra 5 minutes if you need it. But we realize the questioning went on at length. But
Chief Justice and Justices, I'm Rosemary Daskowitz from Cairncross and Hempelman in Seattle. With me at council table is Holly Franz of Goff, Shanahan, Johnson and Waterman, and Helena. We're here on behalf of the Northwest Women's Law Center. Sitting behind us are the plaintiffs in this case. We intend to divide our time, although we are both prepared to answer any questions that are asked. We would like to we will allocate the last 10 minutes to a discussion by Ms. Franz of the standing issue. This case is about the rights of all of us to engage in intimate sexual activities with our chosen partners outside of the prying eyes of government. Any one of us would be offended if officers of the state peeked in our windows when we were engaged in consensual sexual acts. We learned in the publicity that followed Judge Sherlock's decision that that's exactly what happened in the 1950s to enforce the predecessor statute, the sodomy law, that sheriffs sat on one another's shoulders to look in transom windows to catch individuals in the act. Now that's offensive, but that also violates Montana's Constitution. Montana, in Article 2, Section 10, has enacted a broad, textual privacy right. It is a fundamental right in this state. The Constitutional Convention specifically anticipated that this court would fill in the contours of that right, and this court has done so for the past 25 years.
Well, Counsel, how do you, there's an argument made in the state's brief that Delegate Kelleher, I believe, proposed specific language in Article 2, Section 10, dealing with private sexual acts between consenting adults, and that was not adopted. Would you comment on that?
I don't know, and neither does the state, why the Constitutional Convention chose not to adopt Delegate Kelleher's suggestions. It may well be that his suggestions were made in committee, were made long after the Declaration of Rights itself had been adopted, and were in fact part of a laundry list that Delegate Kelleher brought to the convention. I think 16 or 17 different proposed changes late in the game, each of which were rejected. That may well be the reason. I can't speculate. I can't turn back the clock of history. I know that I myself, and I'm certain that Mr. Smith has scoured the Constitutional Convention, and we cannot say for certain what the purpose of the Constitutional Convention was when it failed to enact the Kelleher Amendment. But we do know that the Constitutional Convention specifically stated that it looked to this court. It anticipated that this court would fill in the contours. The delegates did not want to discuss specific instances where privacy may or may not be applied. They wanted this court to do that, and that is, of course, the appropriate role of the judiciary to analyze and apply the Constitution of the state. Now, the state would have you turn back 25 years of precedent. This court has consistently applied the two-pronged Katz test, even in the town of Venice. In the town of Venice, to the extent there was a reference to the Palco standard, that was used as reasoning for this court to determine just what level of compelling state interest the state needed to apply. So it used that analysis in that context, but it first said, admittedly, the defendant's right to privacy in this case protects their decision to drink whatever type of potable water they choose within their own home.
Well, what do you say about the state's argument that by admitting you've engaged in these acts, you've waived your right to claim a subjective expectation of privacy?
Frankly, there are many things that we admit, but that does not include an invitation to observe the conduct. By appearing in society pregnant, I admit that I have engaged in sex, but I have not waived the right to the privacy of my bedroom. It's the same common sense conclusion in this case for these plaintiffs. Moreover, these plaintiffs were required to make these admissions to satisfy a standing analysis. So under the state's analysis, there would be a catch-22. You could either not admit that you engaged in this conduct, and then you would not be able to show how you were part of a group that was uniquely harmed. On the other hand, if you admitted that you engage in the conduct, you lose the right. That just doesn't make sense as the way to apply a standard.
Why do we need the CAT standard in this context? Isn't it, as you've just suggested, isn't it just a lot more simple than that? The Article 2, Section 10 guarantees textually people the right of privacy in Montana. I think nobody disputes that having sex is one of the most private things people do. Why do we need to go beyond that?
Well,
why do we have to develop some sort of a complicated analytical framework to simply agree on the obvious?
Well, there is a complicated analytical framework in place, and in this case, the obvious fits well within that framework, which is to look first at the plaintiffs themselves and say, do they have an actual or subjective expectation of privacy, and then look at the society in general. Do we all have an expectation that that sex is a private question? Then the second part of the privacy analysis is, okay, you've got that right to privacy, but is there a compelling state interest for the state to carve out gay men and lesbians from that exception, from that rule? Do they have a compelling interest to apply an exception? And in this case, the state has just conceded that they do not have a compelling state interest. They have not stated one in their briefing. Neither the societal notions of inappropriate conduct, which is essentially a way of saying, we don't like you, we don't like this conduct. That's not a compelling state interest. Romer v. Evans, the city of Cleburne cases from the United States Supreme Court, makes clear that you need more than animus against a group to satisfy a compelling state interest case.
The state argues that if society was prepared to recognize an expectation of privacy in this situation as reasonable, there wouldn't be a law against it.
The state needs to do more than just point to an animus. It may well be that a majority of the legislature in Montana finds homosexual sex to be abhorrent or distasteful. But the purpose of a constitutional analysis is to protect the minority from the tyranny of the majority. You have a constitution in place to determine whether or not that act of the legislature violates the Constitution. If you accepted the state's rationale, any time the state acted, you would be immune from reviewing that law, because the state would say, well, there's no societal interest here.
If we apply the Katz test, which is what you're advocating, in spite of Justice Nelson's question, and we get to the second prong, which is that this is an activity in which society is willing to recognize an expectation of privacy as reasonable, then how do we determine what society's willing to recognize as reasonable without regard to how society has spoken through its elected officials?
I think the error in the state's argument is that it focuses on whether or not society thinks that sex between persons of the same sex is private. The issue is first whether sex is private. It's only when we get to phase two, the compelling state interest analysis, that you look at whether or not there is a compelling state interest to support what the legislature has done here, which is to create an exception for gay men and lesbians. Now, the privacy is a fundamental right under the Montana Constitution. In that sense, this is a different analysis than the United States Supreme Court applies. The United States, does not have a textual privacy clause. So we are starting from a different base. The analysis under the implied penumbral rights under the Fourth and perhaps the Fifth and the 14th Amendments requires the United States Supreme Court to apply a different test. That's not necessary here and hasn't been necessary in any of the decisions of this court. The other federal decisions, specifically Bowers v. Hardwick, aren't helpful because, again, this court has repeatedly reminded us that Montana's protections are broader. Montana provides a greater protection of privacy than the United States Supreme Court does. And the Bowers court itself recognized that that case should not be used in any way to limit the right of state Supreme Courts to interpret their own constitutions. Now, when considering whether or not the state has a compelling state interest, it's important to remember that the court simply does not pull these out of thin air. Oberg makes it clear that there must be something within a statute that gives some indication of why a statute supports a compelling state interest. We've already discussed briefly the notion of the societal notion of appropriate sexual conduct. Does that support a compelling state interest? Again, it is not a compelling state interest because the bare desire to harm a politically unpopular group is never a legitimate state interest. It has never been recognized by this court. The second potential argument, which is, of course, the health concerns, specifically limiting the spread of AIDS, as Mr. Smith stated, these must be drawn very carefully, these types of statutes. And this statute has not been drawn carefully. It covers conduct which has an extremely low AIDS transmission rate, that would be lesbian sex. It ignores heterosexual conduct, and excuse me for being graphic, but anal heterosexual sex, which has a higher transmission rate as well. Privacy is about the right to be let alone. All of us expect that sex is private. The state fails to demonstrate any reason, let alone a compelling one, to carve lesbians and gay men out from this general rule. And that is what Justice Sherlock concluded.
If we uphold Judge Sherlock's decision that privacy encompasses consensual sexual activity, would that in turn invalidate laws against prostitution, for example?
Justice Liepart, those laws against prostitution, such as the one that was upheld by the Florida court in the case that Mr. Smith brought to our attention recently, Roe 2 v. Butterworth, there are compelling state interests for other types of laws against prostitution, against polygamy. We have determined as a society that they pose societal harms, that the activity that surrounds prostitution is detrimental to society as a whole. In those cases, again, the state would need to show a compelling state interest. Now,
but it is consensual sexual activity.
Yes, and so therefore there may well be a right to privacy in that activity, but nonetheless, should the state satisfy a compelling state interest, any such legislation can certainly be upheld. And
what would be the compelling state interest for outlawing prostitution?
The compelling state interest for outlawing prostitution would include the subjection of women and the differential in power that prostitution has caused. It is one, if you read feminist jurisprudence, it is one of the factors which has contributed to the debasement and the degrading of women. There's also the notion of sex for hire involves an economic side, and there is an economic argument which the Roe v. Butterworth or Roe 2 v. Butterworth found persuasive, that the state has a right to legislate in economic arenas, and it has done that by outlawing prostitution, by saying this is a type of commerce that the state of Florida does not accept. A similar argument could certainly be made, although I haven't certainly researched and briefed what frankly, I'm only presuming that prostitution is outlawed in the state, but I haven't researched and briefed what the reasons for that decision were by your legislature.
So in the case of prostitution, you're not outlawing the sexual activity. What you're focusing on is the exchange of money.
Yes, that would be consistent with my assessment, our arguments. Now, there are two other reasons that Judge Sherlock did not discuss, both of which support the overturning of this statute, of the deviant sexual conduct statute. The first is that it violates the dignity clause, and the second is that it violates equal protection. Article 2, Section 4 states in simplicity that the dignity of the human being is inviolable. The state would essentially write this clause out of the Constitution. But the clause is there for a reason, and this court should take this opportunity to start to define and refine the meaning of the dignity clause. The state cites a definition that defines dignity as the quality of being worthy or honorable. We've included a long quote in our brief from Professor Moore that basically can be summarized as saying an infringement of dignity occurs when you attack a person as a person, not based on some injury you have sustained from them or they have received. In essence, the dignity clause is the public analog to the privacy clause. It establishes a right to self-determination, a right to individuality, a right to be whomever you are, all of which are very consistent with Montanans and with the pride of place and the sense of individuality, which is an essential component of at least Montana lore and history, and one would presume current Montana's expectations. The Deviant Sexual Conduct Act declares gay men and lesbians to be criminals because of who they are. This violates their right to self-determination and therefore should be found to be a violation of the Dignity Clause. Turning finally to equal protection. There are three independent ways to get to the conclusion that the Deviant Sexual Conduct Clause violates the equal protection. First, it is not rationally related to even a legitimate state purpose. Second, gay men and lesbians, homosexuals are a suspect class. And third, the statute discriminates on the basis of sex.
Has any court ever held that gay and lesbian people are a suspect class?
There is no court decision that specifically holds that. The Bear v. Lewin, which was the Hawaii case, focuses on an equal protection that the Hawaii case there discriminated on the basis of sex. The problem with relying, however, on the federal precedents are that their argument is basically, Bowers v. Hardwick says we can criminalize, therefore gay and lesbians are not a suspect class. There's a lower court decision out of Cleveland where the court went through the analysis, looked at the factors of suspect class status, and concluded that gay and lesbians did fit those standards, but the appellate court then said, it doesn't matter. Bowers v. Hardwick says we can criminalize this, therefore there's no suspect class status. Now those standards are basically, the standards that this court has applied is the group saddled with disabilities, with a history of unequal treatment, and with political powerlessness. The disabilities that gay men and lesbians face include acts of hatred and violence, living under stereotypes and stigmas. They are not only subject to discrimination, they are these days subject to a political movement which relishes and seeks to enshrine the right to discriminate against gay men and lesbians. Those movements have been successful precisely because gay men and lesbians constitute a politically powerless minority. They are not able to overcome the will of the majority in this case. That's why suspect class status is necessary.
So, Counsel, if we decide this case under equal protection grounds, what level of scrutiny do you think is appropriate?
Because we argue that gay men and lesbians are a suspect class, and because this statute does discriminate on the basis of sex, this court should apply a heightened scrutiny analysis. And that analysis is analogous to the compelling state interest standard we've already discussed. If you'd like me to go through that analysis again, I'll repeat. Even, however, if you look at the lower standard, the rational basis analysis, there must be some basis. This court does not use an any possible purpose standard. Now, to the extent that the Stratemeyer or Stratmeyer case stated that, it was impliedly overruled by Arneson. Moreover, this court has frequently overturned statutes that you could argue, would satisfy an any possible purpose standard. Of course, Arneson itself could have been justified as a way to save money. Cottrell, which is a workers' compensation case, distinguished on your ability to get workers' compensation depending on where you lived. Well, again, if you are living in your parents' home, then you have less of a need for workers' compensation recovery. So again, there could have been a money-saving rationale, but this court rejected that. There could reasonably be a distinction that would require police to take a polygraph while not relying on other state employees to take a polygraph. Police officers, we place our greatest trust in them, yet this court found in Oberg that it was inappropriate under a rational basis analysis to require police to take a polygraph. So this court has done so in the past, and this is another example where the state must do something more than pull a rationale out of thin air. And the final basis for an equal protection argument is the notion that this statute discriminates on the basis of sex. The focus of the statute is not on the conduct, it is on the sex of the person with whom you have the conduct.
But it treats men and women the same way.
Well, in essence, that argument would support a separate but equal distinction between, if there's a classification between men and women that allows the state to let me start that sentence again. That argument would basically uphold a notion that a statute is okay if it creates a separate but equal standard for men and women. Now, that standard has been expressly rejected in the race context. The state points to absolutely nothing that suggests a separate but equal standard is appropriate in the context of sex. The Loving v. Virginia, McLaughlin v. Florida cases focused on precisely this inquiry, which is whether or not the criminal statutes there, the nature of the criminal activity was dependent on the race of the person that you married. They classified the world into whites and non-whites, and if you married within your class, you were fine, but you broke the law, you committed a crime if you married across those lines. Similarly here, the state says...
Didn't that statute just preclude whites from interracial marriage? Didn't it allow interracial marriage among other racial groups?
Justice Treeweiler, that needs to be placed in historical perspective. 100 years ago, the society did not make the distinctions that we make today. There were whites and there were coloreds. And coloreds would have included Native Americans, African Americans, to the extent that there were Asian Pacific Islanders in this to build the railroads. They were all part of the colored classification. So the distinction is different than it would be today. So that I don't think that that argument by the state is compelling, because there is a different historical context of 100 or 150 years ago when those statutes were put in place. The state doesn't cite anything to suggest that there should be a separate but equal standard among the sexes in Montana. Bear v. Lewin, which is the Hawaii state court case, used a similar analysis to conclude that a marital statute, a statute which discriminated between men and women on the basis of marriage, should be overturned, and a similar analysis applies here. Now, the Deviant Sexual Conduct Act is flawed legislation, and this court should find it unconstitutional. Judge Sherlock's opinion recognized that privacy violations occur when the state infringes on the right to be let alone. All of us have a compelling interest. All of us have an expectation of privacy on our intimate relations. There's no compelling reason to apply a different standard to gay men and lesbians. This court should return to all Montanans the right to be free, the right to be who they are, the right to live free from governmental discrimination. I'll give the rest of my time to my colleague.
Very well.
Unless there are questions, I'm sorry.
Chief Justice Carnage, members of the court. My name is Holly Franz, and today my job is to describe standing, to describe the personal stake that the respondents have in this case. In its brief, the state has referred you primarily to federal precedent on standing, but this is a challenge of a Montana statute based upon violations of the Montana Constitution, and it is your precedent that applies to the standing question. And as your recent decision in State versus Bullock shows, this court does not march lockstep with federal precedent on standing issues. You have adopted a two-part test for standing. The first part of the test is, have the respondents suffered a past, present, or threatened injury? And two, is that injury different than the injury suffered by the general public? However, that injury does not have to be unique to the respondents. When you look through the standing cases, although there is no hard and fast rule, the common thread through those cases seem to be direct impact. If the respondents are directly impacted, if they are the target of the challenge statute, then they have standing. The most obvious direct impact of this statute is that it is a felony criminal statute punishable by 10 years in prison and a $50,000 fine. Now, the state tells us that because the respondents have not personally been threatened with prosecution, they do not have standing. But this ignores not only your precedent in State versus Lee, but the precedent of the federal courts too.
Do you think Lee is distinguishable on the basis that in that case the speed limit law was actually being enforced?
No, Your Honor, I do not think it is. In this case, this statute could be enforced at any time, any day, anywhere in this state. Any county attorney could decide to enforce the Deviant Sexual Conduct Act. In fact, the state as much as admits that in its brief, where it stated that one of the reasons why this statute is not enforced is either proof problems or the fact that fiscal resources have been targeted on other criminal activity. There's nothing to prevent a county attorney anywhere in Montana to decide to focus their resources on on enforcement of this statute. So I do not believe that the difference that the state makes there is valid. And in fact, you will see that the state tries to make a distinction between an facial versus an as-applied challenge. And I would like to clarify what exactly it is the respondents are asking for. The respondents, this is a facial challenge to the Deviant Sexual Conduct Act as applied to same-sex activity. The state already has laws that prevent. We have a intercourse without consent law. We have a sexual assault law. We have a law against prostitution. There is no constitutional justification for having a law such as the Deviant Sexual Conduct Act that is specifically targeted and only targeted at same-sex activity. And in fact, one of the purposes of the Declaratory Judgment Act, which is the act that this challenge was brought under, is to allow individuals such as the respondents to challenge statutes that they believe are constitutional without subjecting themselves to the risk of criminal penalty. There's been a lot made in this case by the state that there have been no prosecutions. The record does not reflect this. What the record reflects is there have been no cases appealed to the Supreme Court. We know that. There's no record of appeals. But if you review the record, and particularly the testimony of Linda Gryzcan, the anecdotal testimony in this case shows that this statute has been used to threaten people. But even more important than that, I believe, is the fact that the state has not disavowed prosecution. In fact, as I stated earlier, their brief suggests that this statute could be enforced at any time, and there's nothing in the law that protects any of the respondents from that occurring. If you're inclined to consider federal precedent, I would refer you to Presbyteria of New Jersey versus Floria, which is a case in which the Third Circuit found that a discretionary present intent, which is what we have in this case, present intent not to prosecute, is not enough to deny standing. Now the state refers us...
Excuse me, which case was that?
It's Presbyteria of New Jersey versus Florio. It's a Third Circuit case. It is cited in the amicus brief filed by Lambda.
Thank you.
The state relies on the case Doe versus Dueling, which is a Fourth Circuit case. And much of that discussion in that case focuses on issues of federalism, which I think illustrates why federal precedent on standing is not particularly applicable to this court. In fact, in Dueling, the Fourth Circuit recognized that challenges to state statutes belong in state court, which of course is where we are today. The other part of Doe, in Doe, two single citizens of Virginia were challenging a Virginia statute that had been passed in the early 1800s that outlawed fornication and cohabitation. And in that case, the court denied standing, ruling that that law was nothing but a historical curiosity. Now, in this case, this statute was adopted as recently as 1973. And despite the state's argument, it was not until 1973 that the state of Montana had any legislation that was directly and solely targeted at same-sex activity. Also, in 81 and 91, the legislature amended, fine-tuned the law. In 91, 93, and 95, they explicitly refused to repeal it. And in 95, they also attempted to add a conviction of this law, even for consensual sex, into a violent and criminal sexual offenders registry. So this is a valid law. It's a vital law. And there is, as Judge Sherlock stated, this court cannot assume that law enforcement will continue to ignore this law. But despite whether or not the respondents have been threatened with prosecution of the statute, this law has a direct and harmful impact on them. The law brands the respondents as criminals. And as the record shows in this case, that stigma reinforces hostility. It impacts their self-esteem, how they view themselves, and it also infringes on their personal autonomy. As the state has argued, the mere presence of the law will impact people's behavior. It will prevent them from making decisions and choices that they otherwise would make within their life.
Is it your position that the existence of legislation such as this also encourages discrimination and violent acts and anti-gay attitudes among the populace?
Your Honor, it is. I believe that this type of statute reinforces the opinions that lead to that type of hostility and violence. The fact that the state itself has declared this activity to be criminal adds a mark of approval or state approval on those type of activities that are targeted against the individuals that are violating the law. In the state's case, they focus on Allen versus Wright. It's a United States Supreme Court. And I'd like to cite one passage from that case if I could. In reality, Allen actually supports the respondent's argument. The U.S. Supreme Court ruled, there can be no doubt that this sort of non-economic, stigmatizing injury is one of the most serious consequences of discriminatory government action and is sufficient in some circumstances to support standing. Our cases make clear, however, that such injury accords a basis for standing only to those persons who are personally denied equal treatment by the challenged discriminatory conduct. Based on that finding, the plaintiffs in Allen did not have standing because they had an indirect connection to the discriminatory conduct. They were parents of children who were being discriminated against. I would suggest that the parents in Allen are similar to those individuals that the state refers to who may be sympathetic to the respondent's cause or who may disagree with this law but who do not engage in same-sex sexual activity. Those individuals would have an indirect connection to the statute, and I do not believe they would have standing. The respondents, however, are the direct target of the statute. The statute is targeted at them, and that is why they have standing. In closing,
Oh, you go ahead.
In closing, I would like to again clarify the relief that the respondents are seeking. There is no need for the state of Montana to have a statute that is specifically targeted only at same-sex activity. The plaintiffs seek a declaration that the Deviant Sexual Conduct Act is unconstitutional as it relates to same-sex sexual activity. Thank you.
Welcome. Okay. Any questions? If not, then we... Oh, Clay, you have your rebuttal. I'm sorry. I promised you 5 minutes at least, depending on...
I think I can conclude in 5 minutes.
All right, if you can, that'd be appreciated.
Thank you. Let me reverse the order of the respondent's presentation and talk first about standing. We apparently have a new class of case, which is a sort of a combined facial / as-applied challenge. This is, in fact, by any traditional standard, an as-applied challenge. That is to say, the plaintiffs are not contending that this statute cannot be constitutionally applied in any context. It can be applied to non-consensual sex. It can be applied to same-sex sexual relations between adults and minors, for example. What we have here is a as-applied challenge to a statute that has never been applied to the plaintiffs, which is, I suggest, a contradiction in terms. But that is the nature of the case we have before us.
Counsel, under our Declaratory Judgment Act on the issue of standing, the question is whether the party has sustained harm of some type. It's my recollection that in the last legislative session there was legislation introduced to protect people from discrimination based on their sexual preference, and that one of the opponents at the legislature to that legislation argued that if the activity constituted a felony, then how could you pass a law to protect people from discrimination on that basis? Isn't that an example of harm from the statute?
No, Your Honor. Not harm to these plaintiffs and not harm to any Montanan. What that reflects is a justification for non-passage of a particular statute.
But the statute would have been very beneficial to this class of people, to this group of people.
Perhaps it would have been, but I think the issue again, in this case with respect to standing, is whether the plaintiffs have suffered any harm from the enforcement of the statute. And this statute can be enforced only one way, and that is through criminal proceedings. That,
but their argument is that they're sustaining harm every day from the mere existence of the statute.
Their harm basically is that they're sustaining injury from it because of their emotional reaction to it, as I understand it.
Well, doesn't the declaratory judgment action also provide standing to challenge legislation where injury is threatened? And isn't their injury threatened in this case by the fact that, as counsel has pointed out, the statute's less than 26 years old. It's been amended twice in the last 10 years. The legislature has 3 times denied requests to get rid of it. The Attorney General's office has not disavowed prosecution. Doesn't that all add up to threatened prosecution or threatened injury?
Your Honor, there are 2 components to your question. First of all, I do not believe that the declaratory judgment action changes any normal justiciability principles. With respect to whether the various factors you listed, Justice Nelson, add up to a threatened injury or threatened prosecution, the answer is no. Again, we must determine that with reference to the individual situations of these plaintiffs, and there's nothing in the record to indicate that any of these plaintiffs has been threatened with prosecution. And the mere fact that, for example, the legislature has amended the statute to add provisions that essentially are palliative, providing immunity to individuals from prosecution who undergo sexually transmitted disease testing, things of that kind, hardly, I think, evinces any intent to prosecute these individual plaintiffs.
Well, is it the state's position that the statute is moribund?
No, Your Honor, we've never taken that position. The statute exists. We don't dispute that the statute can be enforced, but the issue is whether there's any evidence in this record, because the plaintiffs, again, have the burden to show standing, whether there's any evidence in this record to indicate that they are in imminent danger of being prosecuted, and the answer is, we believe, no.
Aren't you asking us to assume, though, as a matter of law, that the county attorneys are going to continue to ignore their legal obligation to uphold the law?
Your Honor, I'm not asking, the state is not asking the court to assume anything with respect to the future conduct of county attorneys. What we're asking the court to do is to look at the record to determine whether that record reflects any indication of an intent to prosecute these plaintiffs, and the record reflects none. With reference to the merits, and specifically Justice Leapart's question concerning prostitution, I think Ms. Daskowitz's answer did not address a very difficult question that is raised once this court concludes that sex, because people tend to think it's private, is therefore...
Well, they actually think it's private.
Is therefore falls within the scope of Article 2, Section 10, because by doing that, you indeed do require the state to establish a compelling state interest whenever it attempts to regulate sexual conduct. Now, the mere fact that consideration passes may well not constitute a compelling state interest. I mean, we have, as the court is aware, the state has an extraordinary burden in that situation. And as we suggest in our reply brief, there can be many instances where consideration passes in exchange for sexual relations, where there is no particular harm to either party. In that situation, it may well be extraordinarily difficult to show a compelling state interest. It also would mean that every prosecution for prostitution would turn into an as-applied challenge, where the state would be required, in essence, to establish a compelling state interest under the facts of that case. Now, the court must also consider, and this is my final point, the consequences of establishing, in essence, same-sex sexual relations as a fundamental right. However you do it, under Article 2, Section 10, or Article 2, Section 4. It will mean essentially that the state cannot discriminate against homosexual couples, because in essence the only basis for that discrimination will be the nature of their sexual relationship. It will cast doubt on legislation which, for example, limits marriage to heterosexual couples. It will also cast doubt on laws which preclude homosexual couples from adopting children.
Counsel, I don't understand why a decision which relates to what people do in the privacy of their home would pertain to the issue of whether the state has to issue them a license to do it.
Because under equal protection grounds, the state will be forced to justify why it denies a privilege to one group of citizens and not to another.
Well, so you're limiting this point to the equal protection issue?
Yes, Your Honor.
Okay.
Again, the fundamental right issue cuts across several different constitutional rights. It cuts across Article 2, Section 10. It cuts across Article 2, Section 4 with respect to the equal protection provision. And it affects, obviously, the standard that the state must establish to justify a particular form of regulation. Now, these are serious issues, but they are necessary consequences of what we believe to be socially experimentative theories espoused by the plaintiffs. And we believe that this court, as the U.S. Supreme Court has been in the past and is presently, should be extraordinarily cautious in creating fundamental rights in derogation of what we believe to be a clear tradition to the contrary with respect to this right, at least, in this state's history and in the history of virtually every other state. We respectfully request that the district court's judgment be reversed. Thank you.
Mr. Smith, Judge Sherlock found that apparently the witnesses were credible and that they were threatened by this statute. And the state takes the position that that is not a threat. Is that what you're saying? That the existence of this statute is not a threat to these people and doesn't cause any damages?
Again, Your Honor, I think there are perhaps two components to your question. Let me see if I can parse them. First,
can you answer yes or no on that?
No. The answer to your question, did the district court find that the plaintiffs viewed this statute as a threat? The answer is yes, it did.
And what's the state's position?
The state's position is that the record does not establish any threat of prosecution, which I think was the first prong of your question. With respect to whether, and I think this was the second aspect of your question, with respect to whether or not the plaintiffs have been injured by the statute. Again, this goes back to the question of their emotional reaction to the statute, feeling denigrated by it, for example. And as I've said, that kind of emotional reaction does not, under established case law, constitute a basis for standing to challenge the enforcement or the validity of a statute. Again, this statute can only be enforced in one way, and that's through prosecution.
Why is the statute on the books, is bluntly?
Your Honor, as I've said before, the statute has fairly ancient heritage going back.
21 years?
Well, but the form of conduct itself it has been prohibited since
the Old Testament.
1866 in Montana.
Yeah. Oh.
Earlier than that in other places.
But the legislature didn't do much about it until just a very few years ago.
Well, Your Honor, if we treat the statute as something of a Venn circle, the old Crimes Against Nature statute adopted by the territorial legislature extended to various forms of conduct, both heterosexual and homosexual in nature. What the legislature did in recodifying the criminal laws in 1973 was to pare it down. But the form of conduct in question, I believe, was prohibited, has been prohibited for 130 years.
Okay.
Thank you.
Did you have another question? Okay, I want to get into homosexuality. I just have a little question about the issue of prostitution being raised. And of course I'm aware of the arguments that were made by the respondents with regard to that, but taking just for the court's future consideration in this matter, Judge Sherlock's order and injunction prohibits any enforcement of the statute against those who engage in a homosexual activity if that activity is consensual, done in private, and is engaged in by adults. My question is this: what, if any, impact would that have on, shall we say, adult homosexual acts for hire or prostitution? Does that eliminate that entirely?
Your Honor, clearly the order does not. I mean, what the district court has done is, let me back up for just one moment.
You could fall back on the prostitution statute.
Technically, yes. Technically, if there's same-sex sexual activity in which consideration passes between the participants, it could be prosecuted either under 505 or 601, basically. Judge Sherlock's order would preclude prosecution, as I understand it, essentially under 505, but not under 601.
So there is a remedy that the state would still have.
Oh, yes, Your Honor. I'm not suggesting that.
No, I understand you're not suggesting that. That was brought up.
Counsel, you mentioned the gravity of this decision as it may impact future legislation, especially if we decide it on the basis of equal protection in favor of the respondent. What if a decision is reached under Article 2, Section 4 regarding the dignity clause? Does that have the same consequence?
Yes, Your Honor. Thank you.
Okay, very well. If there be no further questions, cause number 96202, Gryzcan and others against the state of Montana, is now taken under advisement, and we thank counsel for their arguments.